Yes, proceed. May I please, my Lord, I beg to mention item number 9. My senior C mode is out of station, Your Honor. Matter may be listed after 3 weeks.
3 weeks. On a request made on behalf of the appellant, the matter is adjourned to be listed after 3 weeks.
Oh,
May it be pleased, Your Lordship? Lordship, I'll list the matter. This matter may be listed day after tomorrow. It's a PI matter, Your Lordship.
Day after tomorrow, division bench will not be there. You try on next Tuesday.
Yes, sir.
You file it, it will be listed. Fresh matter, you are filing.
No, Your Lordship. It's not press matter.
Then whenever the DB will be there, it will be listed, okay?
DB obliged.
My Lord, I beg to mention item number 11.
11 years.
On behalf of the Tofu, leading counsel is out of station for domestic purpose.
Inform the other side.
Yes, my Lord.
Okay, same order, huh? As on 9.
Please after 3 weeks.
After 3 weeks. And just a minute, Mr. Counsel, this is connected with okay, IA is filed by you. Okay, no problem.
Item number 1.
May please, Your Lordship.
Yes, Mr. Torre.
My Lord, in this matter, the affidavits have been filed. And this is, in fact, my Lord, ready for final hearing. Now, my Lord, I have got some submissions to make, my Lord. This PL was filed, my Lord.
Yes, what is the subject matter?
The student election. APSU election.
APSU election. Elections are already over.
Election. There was an interim order not to declare the results. In fact, my Lord, this PIL is not as such against the present election. There has been, my Lord, the anti-social elements have come in this, my Lord, election process. And every 3 years, my Lord, every at the time of election, my Lord, the many criminal activities take place. After, my Lord, 30th of January.
Since the elections are over, we can admit this and have it for hearing?
Yes, my Lord. There is a
urgency.
Yes, my Lord.
Yes, my Lord.
Another difficulty is, my Lord.
Yes, Mr. Gato.
There is a interim order. My Lord, we may be allowed to declare the result. The election has
Results have been declared before yesterday.
Officially, my Lord, pursuant to the interim order passed by this honorable court on 16. Officially, result has not been declared, my Lord.
Okay.
Though counting, everything has been done, my Lord. Okay. Only to declare the result, my Lord. We may be allowed to declare result, my Lord.
That declaration will be subject to further orders that may be passed. Mr. Chaudhary, what do you say?
My Lord. Let them declare the result, but finally, my Lord. May I make a submission, my Lord?
Yes, please.
My Lord, what I submit is that, my Lord, this PIL is not as such against the present election. The PIL was filed because there was a lot of violence from my Lord, the 30th of January onwards. There have been many criminal cases registered. There have been many allegations against the APSU. They are not following their own constitution. So what I, my Lord, propose, my Lord, what I submit is that, my Lord, there should be a committee because, my Lord, there is a Lindo committee report. Your Lordship must have seen that concerning the elections in the campus, my Lord. Here is a case where, my Lord, a large number of students all over the state and beyond the state, my Lord, they are members and they have to participate in the election. Now, the process they are being followed presently, my Lord, is such that because of which the violence takes place. What I, my Lord, submit before your Lordship, my Lord, there should be a committee formed, my Lord, by the Chief Secretary of the state, so that, my Lord, this type of occurrence does not take place. Because, my Lord, now we find from the affidavit itself of the, my Lord, APSU, that there has been many constitutions, which is the actual constitution is very difficult to say when it was adopted, what was the date. They say that, my Lord, a lot of fake constitution have been in circulation. So there has to be some guidelines under which the election has to be, my Lord, held, so that, my Lord, public at large is not inconvenienced and my lord, this type of violence does not, my lord, recur.
Okay.
So that will be my ultimate, my lord, prayer in the petition.
Okay.
I don't think, my lord, anyone will have objection to that. Even, my lord, the APSU may be a part of that committee that may be constituted, and court can monitor it, my lord.
And Kato appears for whom?
My lord, I'm for the APSU, my lord, the respondent number 4 and 5, 4, 5 and 6, my lord.
So you have taken advantage of Mr. Chaudhary's virtual appearance and come to this side.
Evidently, my lord, since
You should have been along with Mr. Ratan.
my lord, the government side is always occupying
Mr.
the, my lord.
Chaudhary, you have been dispossessed,
Yes, my lord.
taking advantage of your absence.
Well,
Heard Sri M.K. Chaudhary, Senate Senior Counsel assisted by Mr. M. Sharma, Sri M. Sharma for the petitioner. Also heard Sri N. Ratan, learned EAG, as well as Sri M. Kato, learned counsel for the
Correspondent number 4, 5 and 6, my lord.
4, 5 and 6. Para, this court has been informed that pleadings have been exchanged. Para, Sri Chaudhary, the London Senior Counsel, has submitted that submitted that he is not per se against the present election, but the grievance is against the violence, the illegal activities and violence preceding the elections, which are often noticed. He has also pointed out that a committee be constituted to look into the matter and frame guidelines. He has also highlighted the aspect that the present union has numerous constitution, which has led to further confusion, and therefore the guidelines would also require to take into consideration that aspect of the matter. He has also considered that in the committee to be constituted, representative of the APSU can also be part of the committee. Full stop. Admit for hearing, final hearing, Para. Since the parties have been represented and pleadings have been exchanged, there is no requirement to issue further formal notice. Para, the submissions advanced by the learned senior counsel would be considered at the time of the final hearing. Okay.
The declaration of results in this, your worship is saying, my lord.
Yes, this court also clarifies. This court has also been informed that the results are ready and have not been officially declared in terms of the interim of the order of this court. Full stop. We modify the order by directing that results may be declared, which, however, would be subject to further orders that may be passed in this PIL.
Well, deeply.
When do you want a date?
Well, subject to convenience on the part of
Mr. Chaudhary, when can we fix for hearing?
My lord, that any date convenient, your worship, my lord, maybe the month of
We
May,
can have
my
it.
lord.
We can have it in May. 12th of May. Is it okay? 12th
Yes.
of May.
Well,
List on 12th of May.
well, deeply.
Tuesday the DB.
Item number 2.
May I, Your Lordship? Your Lordship, I'm appearing on behalf of El Kurdu, Special PPSIT. Due to domestic issues, he could not appear before this honorable court today. Therefore, Your Lordship, the matter may kindly be adjourned for today.
It's an admission matter. We'll admit it. We'll admit it. We'll record your presence. Okay. Criminal appeal. No point adjourning. Okay. But what is your name?
G. Talo, my lord.
G. Talo. Heard Sri G. Talo, learned counsel for the appellant who has preferred this appeal under so and so, so and so. Huh? Admit. Call for the records. The conviction is under what, Mr. Talo?
My lord, conviction under section 364, 365, 120B, and 34 of the IPC, my lord.
Okay. Sri, your name?
Your Lordship, Y.N. Tamin.
Please write the name. Appears on behalf of Sri so-and-so, Special PPSIT, who accepts notice on behalf of the sole respondent. List after 6 weeks. Same, huh? Along with a report on the receipt of records. Okay.
My lord.
Item number 3.
इसमें सर्विस नहीं है हाँ? एक ही रेस्पोंडेंट. Item number 3, Mr. Kamru.
Yes, my lord. My lord, this article has been prepared, my lord. Against
Against what? Which order?
the judgment order passed by Honorable Justice.
That is okay. What is your grievance?
My grievance is that the learned single judge, while passing the judgment,
You are the petitioner.
yes, has not appreciated the facts that was placed before the learned single judge. The facts, the case in the writ petition was that the petitioner, he owes a land at taxi, whereupon temporary CO building was constructed on the agreement that will be temporary, and it was constructed in the year 2001. So it is, therefore, since it was not donated, neither it was acquired, the administration at taxing.
What was your prayer in the writ petition?
My prayer in the writ petition, my lord, may kindly come to the writ petition, my lord. Okay. Page number, my lord. Page number 30.
But London Single Judge has come to a finding that there was nothing on record to show that you are the owner.
My lord.
Show us something.
Yes, my
You are
lord.
the owner.
Therefore, my lord, kindly, my lord, may I take you to my lord? Take me to page number 44, my lord.
4-4.
44, my lord.
Yes, please.
This is my additional affidavit, my lord.
Yes.
My lord, here I have applied RTI,
Yes.
and it was furnished. And the information I sought was whether the land whereupon the CO building has been constructed, it was ever acquired or donated, my lord. And the reply says, my lord, may kindly come to the my
Yes, 51.
51, my lord.
Yes.
This is the reply of the PIO, my lord. May I read, my lord?
Yes.
In response to PIO's letter number so and so, dated so and so, along with RTI April.
Where is Annexure A? Where is Annexure A to this?
Annexure A, my lord.
The reply is that Annexure A.
This is, my lord.
Please keep on reading. Reply to the
Yes.
RTI.
Yes, my lord.
Filed by so and so.
Yes.
At Annexure A. Where is Annexure A?
My lord, Annexure A is, my lord, page number 50. It must be page number 50, my lord.
50?
Yes, my lord. Forwarding of application, form A, under RTI.
No. Okay, what is the information? What is the information?
Information, my lord, it is that reply to the RTI furnished by Sri Karu Chedatro, PIO Dapurijo, dated so and so, at Annexure A. In response to the appeal under since the taxing headquarters is not acquired, my lord.
Serial number 2, my lord. In response to the appeal under section 19, clause 1, since the taxing headquarters is not acquired or notified by government of establishment of circle headquarters, has all the information sought by the applicant, Sri Karu Chedar, from serial number 1 to 15 are not available in the office of the district land revenue and settlement officer Upper Sibachur district, Daporeja. So here, my lord, in response, the PI is saying that since it was not acquired or donated, therefore, no record is available in the office of DLRSO Daporeja, my lord. Now, again, my lord, coming back to my writ petition, my lord, in at election, my lord, there was minute of meeting, my lord, at page number 42, my lord.
Page 42.
Yes, my lord. Since, my lord, the land was never donated nor acquired, my lord. So, therefore, the CEO of this circle, my lord, he convened a meeting, my lord. This is the minute of minute drawn on that day, my lord, on 5th May 2025. Married, my lord. Page number 42.
Please read.
A coordination meeting, wide order number so and so dated 23 April 2025 on land demarcation matter.
What is the present status now?
Status that, my lord,
They have demolished.
they have demolished, but they have not created the new structure because it was demolished for creation of new structure. Since the case, the petition was pending, and in the judgment it said there is a, my lord, it has been provided that demarcation verification has to be done, my lord. Before it is done, no construction.
Verify. What is your difficulty in the verification process? You participate in the verification process.
My lord, since, my lord, there is
Let us see the direction again, page.
page number, my lord, page number 38. Page number 38, my lord.
86, Lordship.
Oh, sorry, page number 86, my lord. Yes.
There are 15, Lord.
Let us see the direction.
There are 14 and 15, Lordship. But 15.
To verify the claim of the petitioner on the basis of the veracity, if during the course is found, where is your grievance?
My lord,
Verify.
my lord, since, my lord, in the writ petition, my lord, in the writ petition, I have annexed 3 documents, my lord. That was official document, my lord. It was not created by the petitioner, my lord, the appellant, present appellant. Firstly, my lord, there was.
No, understood, Mr. Kamruk. The learned single judge has asked them to make a verification exercise. You might be possessed with certain documents. They'll examine the documents and they will come to a conclusion. Thereafter, they'll take a decision. Why are you aggrieved?
Therefore, my lord, my apprehension is that, my lord, since the administration, my lord.
No. Madam, you do this, carry out this exercise fairly in accordance with the directions at paragraph 15.
Yes, Lordship.
My lord.
Clear, Lordship. Before verification, they cannot construct the.
If it's, see, Mr. Kamduk,
Cannot be done.
here we find that you are mainly on apprehension, that the verification part may not be done fairly.
Yes,
If you
my
have a
lord.
grievance that the verification has not been done fairly and in an incorrect manner, you can come to this court.
My lord, otherwise, yes, my lord, that is there, my lord.
Clothing.
But, my lord, from the minute, my lord, it is apparent, it is evidently clear that, my lord,
Learned single judge has not taken a decision.
Yes.
He has sent the matter back to since there's a dispute. Okay, they'll consider all the documents, including the minutes.
yes, my lord.
Okay.
Since this is honorable court's direction.
Yes. Third, we'll close this. No?
Yeah.
Third, Sri D. Kamduk, learned counsel for the appellant. Also heard Ms. G. Ete, the learned, your additional senior advocate.
Yes, Lord.
Arunachal Pradesh. Para. Considering the subject matter in this appeal, comma, the same is taken up for disposal at the admission stage itself. Para. The appeal, the intra-court appeal has been preferred against a judgment dated 27/3/2026 passed in WPC 206 of 2025. Para. The relief sought for, prayed for in the writ petition reads as follows, page 30 to 31. Quote, para. The learned single judge, by the impugned order, has come to a finding that there was no prima facie, there was no documentary proof that the petitioner had lent the present parcel of the land. Full stop. Accordingly, nonetheless, a direction was issued to the respondent authorities to verify the claim of the petitioner on the basis of the representation filed by him on 28/4/2025. We come to the learned counsel for the appellant has submitted that the learned single judge has not appreciated all the facts which were on record, including the minute submitting.
And
Full stop.
yes,
He has also submitted that the materials on record would show that the petitioner had a valid claim. Full stop. Para. We are, however, of the opinion that the present appeal has been preferred primarily on apprehension that the case of the petitioner would not be fairly considered. Full stop. Para. The law is settled on the scope of interference in an intra-court appeal, which has been laid down in the case of so-and-so in the following manner. Quote kar dega. Para. We have also noted that the ultimate direction is for a verification of the claim of the petitioner based on the representation. Full stop. We are of the view that the aforesaid direction does not require any interference. Full stop. We, however, add that while making the said verification, all the materials, including the minute submitting, dated,
my lord, dated 5/3/2025,
5/3/2025,
and my lord,
and all other relevant documents be taken into consideration by the respondent authorities.
and my lord, verification may be made in the presence of the appellant.
Yes.
Verification that will be carried out, may be carried out in presence of the.
However, it is needless to state that such verification exercise, that while conducting such verification exercise, the appellant may be involved by securing his presence.
Much obliged.
Item number 4.
Orders, right?
May-
What is it, Mr. Bori?
Lordship, here,
Memo
There wa-
appeal as well as application for convention
yes,
not yet filed by the learned LSC for.
Lordship, I have, for obtaining signature, I have already sent on 21st March 2026. Convict is at Teju jail.
When can you file? When are you expecting to file?
Now, already, Lordship, from the Teju jail, I have to receive that,
Okay, we
copy.
grant a month's time. Is it okay? 1 month?
Okay.
1 month.
Yes, ma'am. Yes, ma'am.
Peruse the office note dated 6/4/2026, as per which memo of appeal as well as application for delay condemnation are yet to be filed by the learned LSC. Full stop. Para. Sri U. Bori, learned LSC, has informed this court that the memo of appeal as well as delay condemnation petition has already been prepared and sent for signature to the Teju jail.
Teju jail, Lordship.
Teju jail. He accordingly prays for some time. Para. Also heard Sri T.A.
Yes, madam.
Learned your APP,
Yes, madam.
APP, Arunachal Pradesh. Para. In view of the aforesaid submissions, matter is adjourned by a month to enable the learned LAC to file the memo of appeal as well as the delay condemnation application.
Obliged.
Should we fix a date?
But let it be then listed immediately after filing of the this.
The matter may be listed immediately after filing of the aforesaid by the learned LAC.
Yes, obliged.
You try to expedite, Mr. Bori. You give a reminder to the, okay. This matter should not be delayed. Conviction of which year? 24, I think.
Yes, Lordship.
23, madam.
23.
Yes, madam.
21/7/20.
Already more than 2 years have passed.
Yes,
Yes.
696 days delays.
No delay we can condone.
Yes,
Only we need the application formally.
Yes,
We can condone the delay. Okay.
obliged, madam.
And conviction is under what?
POCSO.
POCSO.
Yes.
Age of the appellant?
Age, Lordship, it was 23 years.
No, you're 23 at the time of conviction.
That time of
And when was the occurrence?
occurrence, Lordship, I have to see. It was on 27/7/21.
21.
Yes.
Okay.
Victim age was below
Item
12 years, madam.
Item number 5.
My lord, I am legal aid counsel for appellant, and I have not received paper book.
Paper book has been prepared.
Lordship, item number 5 and 6 is arising out of the same session case number, Lordship.
5 and 6 are connected.
Yes, Lordship, same session case number. This year, with regard to item number 6, this year was received, Lordship. Paper book not prepared, Lordship.
But
And
records have come.
Yes, it appears, Lordship.
Lordship, in item number 6, I have received the records, Lordship.
Record is there. Records have come. No. Record is there. Yeah, records have come. Just a minute.
And Lordship, memo of appeal was not prepared, Lordship, in item number 6, Lordship.
Same problem.
And there is a delay also, Lordship, in
Delay of how many days?
delay of Lordship.
And Madam, have you filed delay condonation application?
No, Your Honor, I have not received any record, my lord. I have just appointed as a legal aid counsel, and I have not received any records.
This was registered on the basis of what? It's a jail appeal or what? Jail appeal.
Yes, it's jail appeal, Lordship.
We can condone the delay.
Yes.
Okay. And Madam, for whom?
Lordship, in item number 6, Your Lordship, I'm appearing for the first time, Your Lordship.
5 and 6 are connected.
Yes, arising out of same judgment.
Okay. Then we can do one thing. We'll ask the paper book to be prepared.
Lordship.
We'll condone the delay. Okay.
And Lordship, direction may be given to prepare memo of appeal, Lordship.
Prepare the paper book. Not memo of appeal is not required. Why is it required? We will not be so technical in criminal appeals from jail. Pursuant to the earlier order passed by this court, the trial court records have been received. Full stop. We have also noted that while order dated 29/8/2025, TCRS were called for, the appeal is yet to be admitted. Full stop. Let the appeal be formally admitted. No, yes. Let the appeal be formally admitted. Let the paper book be prepared by the registry, whereafter these appeals be listed for orders to fix a date of hearing. We also make it clear that since these appeals have been preferred from jail, the delay, if any, stands condoned. Please record their presence, sir. Madam, for both, you please give your names in both the appeals and Learned PP, APP. What's his name? Deloy, PP. PP. And Madam's name, one is J. Doji, Learned Legal Aid Council in Criminal Appeal J17, and N. Anju, Legal Aid Council in the other one.
As amicus.
You are an amicus. And Anju amicus, huh? The first is Legal Aid Council. Okay.
Item number 7.
With petition.
Yes, Lordship, the accused has been inside the jail, Lordship, on preventive detention since last 4 months plus.
Under which act?
It is
Pete and DPS.
NDPS, but
Pete and DPS.
yes, NDPS, but on NDPS he has been already released on bail. But on to maintain public order, he has been put on preventive detention. This is the case. Can you see, Lordship? Page number 28, enacted free. This is the release order passed by the trial court. Already this charges and which accused has been charges.
No, see, this has got no direct connection. This is a preventive detention,
Yes,
PIT, PIT and DPS.
that is why.
There is an apprehension of you being involved in further offense. That is
Actually,
the purpose of having you in custody as a preventive measure.
that apprehension is not real, Lordship. Kindly see the police report, page number 26. Kindly see.
See, have you been allowed to go on bail or have you been acquitted?
Allowed to go on bail.
The trial is still on.
Trial is still on. Trial is going on from the jail.
Even an acquittal on the basis of reasonable benefit of doubt will not be sufficient unless it is an honorable acquittal. That might be a factor. But what is the tenure of a preventive detention?
Lordship, it is generally 3 months, but I have already crossed the 4 months.
Yes, Mr.
Kindly see region.
So, Nawam, what do you say?
My lord, here, the detainee is she is a drug peddler, my lord, habitual drug peddler. I think within the ICR, my lord, there will be any police station where FIR is not lodged against her, my lord. My lord, she was released again, my lord. Lady, my lord. She is a drug peddler, a habitual drug peddler, my lord. My lord, now she has been released. Again, my lord, reactivated. Again, my lord, she do the same, my lord, things, my lord. And if your lordship see the SP, my lord, recommendation, my lord, then what affidavit? My lord, page 73. My lord, based on this, my lord, this lady was, my lord, in a preventive measure, she was, my lord, detained, my lord. Now, my lord, she has submitted the representation, my lord, the representation of property to the board, my lord. The board examined both, my lord, SP and the representation. Then board also found, my lord, her, my lord, preventive detention necessary, my lord, to prevent the message of these drugs, my lord. Your lordship knows how dangerous drugs,
No, those are on the merits. We are on the procedure part.
Procedures
in these preventive detention matters,
my lord.
The concern is more on the following of the procedures laid down.
Yes, my lord.
Did you follow?
Yes, my lord. The representation which submitted, my lord, that was immediately forwarded to the my lord, board, my lord. Yes, my lord. The board was constituted on time, my lord. The board they examined. Your lordship can see the board report also, my lord. We have annexed in our affidavit, my lord. So the procedure, my lord, I don't find any flaws committed by the authorities, my
Mr.
lord.
Tapak, this petition is structured on what violation? Procedural violation of what? Merits? do not have much scope to interfere.
Only what they are saying, my lord.
We will release the procedure.
My lord, only what they are saying, my lord, in one of the case, my lord, she has been released on bail, my lord. That is the only one of them.
My submission is, Lordship, kindly see the page number 26 of police report, Lordship.
Yes.
The law on which I was arrested,
Yes.
it was found to be not a case of, it's a drugs case. It is not a case of NDPS case. Police has already filed closure report on that case. Kindly see page number, read
There are multiple
substance, the item, the substances, drugs in question. The substance was sent to FSL report. The FSL report has said it is not a case of, it is not the substance doesn't come under the purview of NDPA. Accordingly, closure report has been already filed by the police. Then in the meantime, the ground for my detention, preventive detention, was that I'm again involved in such drugs case in violation of the previous bail order. It was the issue. But during the course of investigation, I was found to be not involved in such drugs case by the police. Then accordingly, the trial court, in the previous case, there was two ongoing, this trial case, that bail was also cancelled. And in all three cases, there is a pending 3 cases against me. In 3 cases, already I have been released on bail. Even then, when I
see, Mr. Tapak, you have only mentioned about one case where there is a final report.
Yes.
What about the other cases?
That is a 2021 case. That is trial is going on. I am cooperating here.
21 cases, but all cases on NDPS.
Yes. That is not the
What
case.
more is required?
Kindly see the page number
See,
1.
we cannot look into the aspect of satisfaction of the detaining authorities, which is subjective in nature. We can only look into the grounds of procedural violation. You make out a case that this procedure has been violated.
That is not the case. Court, this review committee has to show the live link. What is their apprehension? Kindly page number 24 of their affidavit, government affidavit.
3 cases are already there. 3 cases you are facing trial. One case there may be an FR.
Criminal law justice system is person is presumed to be innocent until he is proven guilty.
Then we'll have to repeal this PIT and DPS.
Kindly see page
There's
number
no requirement of PIT. What is the requirement of preventive?
Kindly see the page number 124 of the government affidavit. Kindly see what is the regions kindly see reasons for detaining the detainee, Lordship. There is reasons is very casual. Reasons has been cited saying that although bail is granted, although close report is
Mr. Tapak, you just show us
I cannot.
Mr. Tapak, show us the law that while adjudicating an application of this nature, we can go into the aspect of subjective satisfaction of the detaining authorities. We can look into the procedural aspect. Make out a case of procedural violation. We'll look into it. We'll interfere. Now, whether there were sufficient materials or not,
Lordship,
there are.
Lordship, detaining authorities to show live link what is the next offense going to be committed by the accused. Unless that is shown, live link is shown, in the name of law and order, I cannot be detained. That is a violation of Article 22. That cannot be lost. That is, I have the citations. It's Amina Begum case.
Okay, we'll have this for hearing then. We'll have this for hearing. We'll have this for hearing.
Yes.
Today is for what? Today is for hearing only, no?
Today is for hearing.
Today is for hearing.
Kindly see page number. That may be read ground given by this government.
It's for orders. We'll have it for hearing.
Yes, Mala. If your lordship see, your lordship may kindly see the Mala page number 73, Mala.
73.
73, Mala.
This
should clear for everything.
73. What is this? Justification.
Yes, justification for purpose of
has been continuously involved in illicit trafficking.
Correct, Mala.
Of NDPS, posing serious threat to public order, public health. She has persisted in her illegal activities, showing complete disregard for law and authority. Intelligence inputs Yes, these prevent her from continuing, break the chain. These are good reasons.
These are bona fide good reasons for that.
Lordship, as per the Supreme Court case, the authority should say the live link for detention. This is not the punitive case, punitive detention. This is detention is for to prevent this next offense, Lordship.
See, you are
This is the purpose.
you are an accused in 3 cases. They have come to this satisfaction.
Not 3 cases, only 2 cases. One already closure report has been filed, and 2 cases is already trial is going on, Lordship. I'm cooperating, Lordship. Why I should be detained without showing any live link? To be
What
obviously
what about the satisfaction, justification? Page 73.
Uh,
16.
Before that, kindly see page number 124 of the government affidavit, Lordship. What is the reasons this given by the board? Lordship? Kindly that may be seen.
120.
Advisory board.
Yes.
Page number 118 is there. Advisory
124.
board decision.
Yes.
And operative portion is page number 124.
Yes.
This second last paragraph, second last paragraph. May I read the content? Peruse the representation dated 13/2/2026 made by the Muhammad Nazir Ali on behalf of the detainee as the husband of the detainee. In paragraph 2 of the representation, the ground taken is the detention has been forced on the detainee without following the mandatory procedure under the preventive detention law. As the ground taken in the representation doesn't disclose to which mandatory procedure doesn't had not been followed. The two. I continue.
So matter listed for orders. If you would you like to proceed with the hearing or?
Today matter may be hard, since it is a.
But we privacy found that finds that there's nothing. You have not said anything on the procedural lapses.
And the procedure
or the procedural aspect.
procedural lapses is allegation is Lordship.
See, basically these preventive detention cases are fought on technicalities.
Lordship, that is.
I mean, particularly the violation of the procedural parts,
Yes, procedure.
not on the merit as such.
That is why procedures for what procedure safeguard is number one, Lordship. I am.
Whether is there any violation? Whether you have at least any violation of the
Yes.
procedure.
Procedures, Lordship, why I should be taken on preventive detention, whereas the case is a false case against me.
That is not a procedural violation. That is a subjective satisfaction. That is you are not understanding. If there is a delay in the consideration of the representation, delay in forwarding a representation, delay, all those are things.
My submission is, Lordship, I have been already released on bail by the.
Those are on the merits of the case. We are not entering into the merits.
And over the case already, Lordship, the case on which I was arrested, that has been found to be false, Lordship. False implication.
There are 2 other cases.
Yes. And 2 other cases has been going on since it is a 2021 matter.
Oh, I just
Today
indicating.
it is 2026, Lordship.
We're
Yes, going on.
Sir, we're repeating. These preventive detention cases are fought on technicalities.
Yes.
Violation of the procedural law. You have not said anything. So even we cannot hear you, in fact. You have not said anything. You have not taken any ground.
That is why, Lordship.
And the grounds you are insisting
On merits.
again and again, it's on merit.
I can, Lordship, file additional affidavit because I have not challenged that advisory board or this board order because at that point, well.
I think you better file an additional affidavit or
Board decision, Lordship. As per the board decision, its board decision has come out on the basis of my representation. I have said that the case is false case. I am innocent.
false case.
But the board has
False case.
What is the
Innocent.
Yes,
This we are not going to consider. That cannot be a ground. You better you file an additional affidavit, whatever you want to take whatever grounds you would like to urge See, we
Lordship may consider.
try to understand.
Lordship may appreciate the matter, Lordship. Kindly see.
We cannot appreciate because you have not taken any ground. This is a preventive detention case.
That is why, Lordship, page number 124, last paragraph, second last paragraph, Lordship. What is the observation of the board decision, Lordship? This honorable court has the.
Okay, we have heard you. Will pass the order. Then. You are since insisting.
Yes.
Okay, please write. Heard Sri T. Tapak, learned counsel for the petitioner. Also heard Sri R. H. Nabam, the learned AAG, along with Sri so-and-so learned PP, the learned PP. Para. Though this matter is at the order stage, comma, the learned counsel for the petitioner has insisted upon its hearing as it relates to preventive detention. Para. The petitioner has put to challenge
Preventive detention order.
An order dated 28/1/2026 passed by the Commissioner cum Secretary, Home, Government of Arunachal Pradesh, under Section 3 within bracket 1 of the PIT NDPS. Rightful, huh? Prevention of illicit traffic in narcotic, drugs, and psychotropic substances Act 1988 within bracket PIT NDPS. Full stop. It is content. Sri Tapak, the learned counsel, has contended that the petitioner has been released on bail by the learned special judge NDPS UPA. Full stop. He has also contended that in one of the cases, the police has filed final report, and in two cases, the trial is going on where she is on bail. Para. On the other hand, both Sri Nabam as well as Sri Louis, learned Nabam learned AG and Louis learned PP have contended that the challenge is mainly on the merits of the case and not on any procedural infirmity. Para. On a specific query by this court, the learned counsel for the petitioner has not been able to make any submission on violation of any procedure leading to the detention. Full stop. The submissions are mainly on the merits of the case. Full stop. He has also contended that in the final report submitted in one of the cases, the substance itself was found not to be a contraband under the NDPS. Full stop. We are, however, of the view that in a matter of preventive detention, the challenge can be examined, which are mainly on the procedural aspect. Full stop. The subjective satisfaction arrived at by the detaining authorities, which has been confirmed by the advisory board, cannot be matters of inquiry, of roving inquiry by this court when prima facie this court does not find any illegality or impropriety in the said order. Full stop. In view of the above, the writ petition stands dismissed.
Item number 8.
May I please, madam?
Yes, Mr.
But
Padre.
there is a delay application also there. II for delay, and I have taken a step. I have submitted the copy of
delay application notices have been issued.
Yes, madam.
You have taken
Pro PP, madam.
It's POCSO.
POCSO, yes.
Yes,
POCSO.
report, Mr. Louis.
Lordship, we step taken, Lordship, but
application for condonation of delay.
Yes, my lord.
Full stop. Notice was issued in this case, which was routed through the office of the learned PP Arunachal Pradesh as the offence involves the POCSO Act. Para? Perused the communication dated 7/3/2026 issued by the officer in charge, Koloriang Police Station, as per which the notice has been served upon the younger brother of the victim. Ria is the victim.
Father.
Younger brother of the informant.
Yes, my lord.
The
Father.
informant. Para. Since, however, the informant has not appeared. Full stop. Para. Since the conviction involves the POCSO Act as mentioned above, comma, this court accordingly appoints, yes, amicus, anyone in the court or legal aid counsel? You're an amicus? I appoint Sri U. Buri, learned amicus curiae to appear on behalf of the respondent number 2.
Yes.
Full stop. Office is accordingly directed to furnish all the relevant documents to Sri Buri. Full stop. Would you like to file any objection to the delay condonation, or you like to contest on the merits? Will condone the delay because no point in a criminal appeal we like to examine on merits. How much is the delay?
My lord.
How much is the delay?
428. Yes, ma'am.
We condone the delay.
But in his prayer, in your prayer person, it's 453 days.
My lord, that's a clerical error. I have made it corrected in some.
Okay.
428.
Yes, my lord. 428.
So, Sri Bori, the learned amicus curiae, has submitted that the contest would be made mainly on the merits, primarily on the merits of the appeal. Full stop. The aforesaid aspect is also endorsed by Sri D. Louis, the learned PP, Arunachal Pradesh. Para. The law on the aspect of condonation of delay is settled, wherein there is a requirement of a justice-oriented and pragmatic approach. Full stop. We have also perused the grounds cited for condonation of delay. Full stop. Para. Considering all the aspects, including the aspect that the appeal is against an order of conviction, comma,
yes, yes.
We are inclined to condone the delay of 520 days, 420 days,
yeah,
which we accordingly do. Para. Let the appeal be registered and listed for admission after a week. Para. Let the name of Sri U. Bori be reflected in the cause list as amicus curiae.
Of like
428.
428. Yes, madam.
28.
28. 428. Yes, sir. Of like.
Item number 10.
Step ahead. Good. Otherwise, it will stay like this. Item number
10.
10, Lordship.
10. How many witnesses, madam?
6, Lordship.
6.
Yes, Lordship.
How long will you take?
Lordship, no, not much, Lordship. There's very simple actually. There's only one eyewitness, Lordship, here. Ocular witness is PW1,
We
Lordship.
can dismiss it.
No, Lordship. Lordship.
Very simple, one eyewitness.
Yes, Lordship. And however, Lordship, here, what happened was that the weapon of offense was not discovered. So,
Under section
302. Lordship, this FIR is at
Today it may not be possible.
Yes.
There is a single bench and in the
Yes.
afternoon, as you know, there is a
Yes.
program. And
Yes.
we'll request all of you to be there. And it might go to the second half. So second half sitting may not be possible. We'll have some other day.
Yes,
Okay. It will not take much time. Finish it off. When next Tuesday?
I think vacation
Oh, next Tuesday is the vacation.
after on 21st, Lordship.
On 21st is okay.
No, Lordship, last part was 28, 29,
28?
Lordship. Yes, Lordship.
Mr. Bori, 28?
Yes.
Okay, anytime, Lordship.
On a joint request made by the Learned Council. No, don't select this. Part 3, you, Bori. Learned, your legal counsel.
Lordship, here I'm amicus, Lordship.
Learned amicus curiae for the appellant. Also heard Miss Al Hage, Learned APP, Arunachal Pradesh, Para, on a joint request list for hearing on 28.
Lordship.
4. Okay.
Much obliged. Of judgment, item number 1.
As regards the challenge to the act of recovery of so-and-so, this court has noted that the impugned order dated has taken into consideration all the different instances wherein the misconduct of the petitioner becomes apparent. Amongst the allegations, there is a very serious allegation of opening an account in the name of the branch of the bank itself by using the pen and pen, and the same are not denied. This court is of the opinion that under such facts and circumstances, the respondent bank has rather taken a softer approach in terminating the services in accordance with Regulation 9A and has not lodged any police complaint. This court is accordingly not inclined to direct refund of any amount. The petitioner towards the last part of his submission has expressed his apprehension of prejudice in case he applies for any other job. This court has given its anxious consideration to the said respect. The impugned order dated so-and-so is ultimately issued as per Regulation 9A of which is in connection with confirmation or otherwise of an officer under probation. In that view of the matter, this court is of the opinion that the interest of justice will be served by directing that the impugned termination order dated so-and-so is to be deemed as a termination simpliciter, which would not have any impact if the petitioner applies for any other job as per his qualification and suitability. Petition accordingly stands disposed of in the manner indicated above.
Please, Lordship. Lordship, yesterday, a bunch of writ petitions were disposed of analogously. 4 writ petitions were left out. Can it be taken up tomorrow? Similar order for. I have even taken consent
Tomorrow,
from
this court will have difficulty.
day after tomorrow, Lordship.
Day after tomorrow, if my brother has, this court will not be there.
Otherwise, it's same set of one.
Day after tomorrow, you can try. You can place this judgment. This judgment, I think, is already online.
Yes, Malad.
You are there, Mr. Top.
Yes, sir. Yes. I have taken consent from him, Malad.
You could have moved it today itself.
I thought, Malad, the DV was there, so this could.
Tomorrow, there will be difficulty because we have to write the judgment.
Malad, the same, similar.
If you say that it is covered by so-and-so judgment, then we can have it tomorrow.
Yes, it's already, Malad.
Have pass a detailed judgment in so-and-so.
Yes,
The
yes.
facts are serious. The operative portion of the said judgment will also cover this case.
Yes, Malad.
But that we can do today itself if you can bring it.
Yes, Malad.
But can you bring it within 1 hour?
All right. I'll
Because
try.
we try to rise early. There is a some function, important function in the of legal services. At least 12:50, 12:45 we are here. Till
Yes,
12:45.
yes, I'll bring.
Okay, try to bring it.
Yes.
Okay.
Nobody wants to adjourn? Nobody will take adjourn. Item number 2 and 3.
2 and 3. Mr. Jinny, what is this?
Lordship, here, in fact, I was the highest scorer in the advertisement post for pharmacist LOPT, Lordship.
Okay.
But due to the name of the degree, my candidature was rejected.
Okay.
In my degree, it is Bachelor of Pharmaceutical Technology. Now they are seeking, what they are seeking is
Yes, what-
Bachelor of Pharmacy.
Instructions.
Lordship,
This matter has been pending since long, though notice has not been issued.
Lordship, in fact, in the another subsequent matter, WPC, item number 3, their notice has not been issued. Otherwise, in item number 2,
Even-
already
3 is pending since 2025.
correct, Lordship. Otherwise, in item number 2, pleadings are completed. In fact, they have sought the instruction also. They have filed their affidavit saying that this Bachelor of Pharmaceutical Technology and Bachelor of Pharmacy are identical posts.
Even in 2, notice has not been issued. Unfortunately.
But then
There was an understanding
understanding
that the matter
instruction.
would be taken up for disposal at the motion stage itself.
Correct.
So you were directed to have the instructions.
Instruction.
If you have the instructions, you can try to dispose.
in item number 3, even we have filed our affidavit also. Lordship.
Okay, then we can have it for admission hearing. We issue a short notice and have it for admission hearing immediately after the break. That break in the week starting from 20th, whichever date suits you. Okay.
Lordship, one development is there, Lordship. Here, Lordship, this particular degree or course, Lordship, whether they are same or not, Lordship. For clarifications, we have written to the Pharmacy Council of India, Lordship, who is the authority who prescribed this syllabus and all, Lordship. We have written this letter on 26 March, Lordship, and we are awaiting for the rest.
Okay.
Their response.
We'll issue notice and
Lordship.
Third, 3, J. Ginny, Learned Counsel for the petitioners. One order, huh? Same order. Petitioners. The grievance of the petitioners is with regard to cancellation of their candidature as candidature for the post of
Pharmacy. Pharmacist.
Pharmacist, full stop.
Allopathy.
It is contended that such cancellation has been done arbitrarily by not recognizing the degree of the petitioners. Full stop, Sarah. Though these 2 writ petitions are pending since the year 2025, notices are yet to be issued on the ground that notices yet to be on the ground that attempt would be made to dispose of the same at the motion stage. However, it appears that there are contentious issues, including the aspect of the validity of such degree, for which, Sriya Stapin, the learned senior advocate, has informed that clarification has been sought for. Flat notices be issued, returnable on, yes, 4th of May, is it okay, 4th of May?
No problem.
4th of May. 3, Tapin, the learned senior advocate, accepts notice on behalf of respondent number 1. Whereas 3, T. Tagum, learned standing counsel, health department, accepts for respondent number 2. Extra copies, I think, are already furnished to you. Okay. Since extra copies have already been furnished, there is no requirement to take to furnish further extra copies. By the next date, further pleadings may be exchanged.
Lordship, in fact, item number 2, Lordship, notice was issued. Lordship.
No, not issued. You check. It's not issued. We have just checked. It's not issued. It's not issued because there was an observation that an attempt would be made to dispose of the writ petition on the next date of listing. You check. We may be wrong. You just check the file. Mr. Tapin, please have your. Just give it to. Both of you, first.
29.
Yeah, this one.
इसमें तो नहीं किया 401 notice was not issued. 329 notice was issued.
329 is not the first matter. It's next matter.
Second.
Okay, it's
item number
3.
329.
Yes.
329 we have not checked.
It was the first writ petition that we have.
Then you're correct. Then there will be some modification. Notice was not issued. This court has, however, noticed that in one of the in one of the writ petition, WPC 401 of, no, 329 notice has been issued. 401 of 2025 notice has not been issued, huh? Just enter that part. Well, I'll check it, just verify it from me. And parties are the same, Mr. Ginny?
Yes, parties are same.
In 401 Lordship, extra copy are not served.
Also, please serve extra copies.
Correct. I'll do that.
Then last part also not required, huh? No need of for furnishing extra copies. Don't write that. Nothing to mention. He'll serve.
Also.
Oh.
Or rather, you said extra copies may be served wherever required.
All
obliged.
Item number 4.
May I please, Your Lordship?
Yes, please.
Yes. Your Lordship, the account of the petitioner has been frozen by the respondent number 2 and 3 in connection with a cyber crime.
Who are 2 and 3?
One is the bank manager of the Canara branch Nahalagan, and 2 is directive police inspector state cyber crime Gandhi
Not
Nagar.
directive. It has to be director of. What is directive?
Director police.
It cannot be directive police inspector. Where is the document from which you have gathered this name?
Page number 10.
10.
10.
Detective. You have written directive. It's detective.
Detective, yeah. Clerical error.
Not clerical. It's a huge error. If you make the detective a directive. And Mr. What is your name?
M. Kamcham.
Kamcham. Mr. Kamcham, you should have, you need to make the bank a party. You have not made the bank a party.
Your Lordship, bank is our respondent number 1.
No. It's not the bank. See who is the respondent number 1?
Branch manager.
The branch manager. You should always make the legal entity a party, then represented by the branch manager.
Yes.
That is the proper arraying of parties. If the legal entity is not before us, we will not be able to give you any direction.
Yes.
Okay? Don't make this mistake. It's the bank or whichever authority represented by branch manager or general manager, whoever. Okay. When your detective is also incorrect, what do? This will not go.
Your Lordship, by way of subsequent affidavit, Your Lordship, I may be to.
Yeah, you file an IA, we'll allow you to correct, okay?
Yes, Your Lordship.
You also make the bank a party.
Yes,
okay.
Lordship.
Third, Sri M. Kamcham, learned counsel for the petitioner who is aggrieved by freezing of his bank account. Full stop. This court has, however, noted that the parties have not been properly arrayed. Para? At this stage, the learned counsel prays for some time to file appropriate IA for amendment of the cost title and implement of proper part of necessary parties. Para? In view of the above, matter is adjourned to enable the learned counsel to file appropriate IA as mentioned above.
Obliged.
List along with the IA which may be filed.
Obliged.
Date?
After filing of the list, so no requirement of date.
Okay, list after. Item number 5.
Yes, what is this?
Lordship, here I'm selling the eviction notice. So wherein I was directed to vacate the premises, Lordship.
What premises?
Lordship, this is my private allotted land, Lordship.
Allotted land?
Yes, Lordship.
You have an LPC?
Yes, Lordship.
Yes, why are you evicting him from LPC land? Or has he encroached any other land other than the LPC land?
Yes.
That may be the case also.
Yes.
What is your name?
Lordship,
Your name?
D. Sekia.
Heard Sri D. Sekia, learned counsel for the petitioner who is aggrieved by a notice dated 31/3/2026, by which he has been sought to be evicted from the land under his possession, full stop. The petitioner has based his claim on the strength of a land possession certificate duly issued to him on 13/12/2016, correct?
Lordship.
Let notice be issued, returnable on 4th of May 2026. Madam Jennifer, for
1 to 5, Lordship.
all the respondents. Okay, one.
No.
Ms. G. Ate, learned additional senior advocate Arunachal Pradesh for 1 to 5. Extra copies, 6 by speed post with ED, steps within 2 working days.
Lordship. Lordship,
Saikya, the learned counsel, prays for an interim order. Full stop, after considering the facts and circumstances, interim order, full stop. The same is, however, resisted by the learned state council, who has contended that the eviction notice may pertain to lands beyond the land covered by the LPC in question. After considering the submissions, it is directed that land which is a part of the LPC dated, what is the date?
13/12/2016, Lordship.
13/12/2016 is not to be disturbed till the next returnable date. The aforesaid interim order, however, would be reconsidered after obtaining of instructions by the learned state council.
Obliged.
Item number 6.
Mr. Patil,
Yes,
what matter?
transport. Transport matter. Now, before I come to argue on the law point, I'll demonstrate the document on what basis I have filed this petition. Now come to the page number 17, Annex 1. This is the impugned order which I am challenged. Now, page number 17, yes, Vijay Patil, the district food civil supply officer.
What is your name, Mr. Patil?
Vijay Patil.
Vijay
Patil.
At page 17.
Yes, page 17.
Okay, just a minute. Page 17.
Serial number 1.
17, serial 1. Yes, petitioner.
Yes.
Where are you serving? This is where of. This is the impugned order.
Impugned order. Now, serial number 3. Danaira. Serial number 3.
You are transferred from your posted as what?
I've been transferred from Pasigat to rowing.
Posted as?
Posted as DFCSO, District Food Civil Supply Officer.
District Food
Civil Supply Officer.
Civil Supply
Officer. Now,
Pasigat to rowing.
Pasigat to rowing.
Okay. Not very far off.
No, not the questions of far distance, not the questions of tenure. Here in the case is come to the serial number 3.
3, yes.
Subdivisional Food Civil Supply Officer.
Yes.
And here, in charge district food civil supply officers. He is transfer and posting is always made amongst the cadre. This is a inter-cadre transfer, which is completely illegal. Yes, that I will explain. I'll explain. In Arunachal Pradesh, district food and civil supply officer sanction post is 17.
Pardon, how long are you staying in Pasigat?
14 years.
14 years?
Yes. 14 years. Now, in Arunachal Pradesh, only 17 sanction posts of the district food and civil supply officer.
Oh, yes.
Now, they have created district around
Dana hearing is response number
4. Response number 4.
is a sub-district food.
Sub-district. He can come to the Pasigat as a sub-divisional food and civil supply officer, but not as a...
You are a divisional or district food?
Yes.
District food or divisional food?
Yeah, district.
So SD is sub-district or sub-divisional?
Yes, sub-divisional. Now what happened? After creation of district, so many districts, around 26 districts also have created, but there is no such post. In such situation, sub-divisional food and civil supply officers have been appointed as in charge of the district food and civil supply officer. I am in a sanction post. Can he replace me? Now, I'll show you. I am a come to the annexer 2, page 18.
So that is your main ground?
No.
That the responsible
Yes.
food who is not in the cadre of the district food and civil supply officer has been transferred with a person who is a district food and civil supply, which cannot be done.
Yeah, I am in group A.
Group A.
Group A officers. And the responsible for is a group B.
Okay.
Now, page 18. Now, again, here, annexer 3, page 20. It has been observed that several SDF, SCO who are posted as in charge of DFCSO are signing the official letters, orders as regular DFSCO, which is considered technically wrong. Such officers should sign as SDO FCSO and in charge DFCSO of the concerned district. Now, he is not a full-fledged DFCSO.
Yes.
Now, again, come to the seniority list. Annexer, page 23.
Yes.
My name is appeared in serial number 2, Vijay Patil, as according to the seniority list of district poor and civil supply officer. Now, serial number 1, S. Chakraborty, he has retired. Now, I am the senior most officer amongst the district food and civil supply officer. Now, the total numbers of our strength is 17, that is page 24. Then, come to the seniority list of the district subdivisional food and civil supply officers. Come to the page 26. If we are in the same cadre, then the question will not arise. Here, district food and civil supply officer is different cadre, higher cadre, group A officer, whereas subdivisional district food and civil supply officers, they are in different cadre. They have got different seniority lists. This is page 26. Come to the serial number 40. Dana Irang, he is responsible for. Now, apart from that,
Serial number, serials are not there. Serial number, what is his name?
Sir, 40.
40.
40.
No, no, okay.
He is a junior most officer, even among the sub-divisional food and civil supply officer.
Okay.
How can he relieve me from my posting place? This is one of the crux of the case.
Okay.
Another point is that come to the Annexure 6,
Page
27.
Yes, please.
Now, last para. It is a unofficial note written by Member of Parliament. In light of the above circumstances, Secretary Food and Civil Supply is requested to look into the matter and transport Mr. Dana Irang from Anini DFSCO to Pasigat DFSCO as in charge Pasigat on compassionate ground. Now, another, come to the page 28, Annexure 7. Come to the last. This is written by Honorable MLA. Considering the above fact, it is therefore requested to the Honorable Minister of Food and Civil Supplies, Government of AP Itanagor to transfer and post Sri Dana Irang.
But these are 25.
Huh?
Last year.
Yes. Now, this is written last year, but they have executed it on the basis of those documents. Now, they have clearly mentioned the Pasigat. That means I have been transferred out only to accommodate the responsible for. Whereas he is not a competent officer to relieve me because by virtue of the cadre, different cadre.
Yes.
No.
Anything else? Okay. Mr. Anything else, Mr. Patil? That's all. Okay. Yes.
My lord, I'm representing respondent number 2 and 3, my lord.
Who are 2 and 3?
2 and 3, my lord. We will need
the department.
My lord. We will need instruction, my lord. But seemingly he has already served there for 12 years, admittedly.
12 years, 14 years, you said.
14 years, my lord. 14 years. And apart from that, my lord, this. Please, brother.
Okay.
Mr.
Jamo, address the court.
No, my lord.
Nothing to be agitated.
It always happens, my lord, from this side. Last time also it happened.
No, it not happened. Mr. Patil is a very senior person.
We respect him. We respect him for that, my lord. But
he's just
sometimes
treating you like his younger brother.
My lord.
That is
No,
okay.
he's elder brother, my lord. And from my own community, but it always happens.
It doesn't. It's not about community. It's the elder brother is an elder.
Your lordship, and
irrespective of whatever community.
This gentleman, private respondent, as per the record filed by them, it appears, my lord, he was already holding in charge there. Of course, from the record, it is clear that he is sub-divisional officer, but admittedly, there are 29 districts in Arunachal Pradesh. Only sanctioned post is 18, not 17, my lord. 18 posts are sanctioned. So obviously, arrangement has to be made by the government. And seemingly, he was there for 14 years. So question of malapidi might not arise. That's why, my lord. I may be given some time to bring the detail, this instruction from them, my lord.
Yes. Yes, madam. Anything? Anything? You're for whom?
I'm to respond number 1.
R1, okay. Heard. 3. M. Patil, Lawrence Senior Counsel, assisted by your name? Your Mugbang Patil. Okay. Mugbang. Okay. Mugbang Patil. For the petitioner. The petitioner has put to challenge an order dated 17/3/2020. Please have your seat. 17/3/2026, by which he has been transferred from Pasighat to Rowing. Full stop. The petitioner is holding the post of District Food and Civil Supply Officer. Full stop. Para. The primary ground of challenge, as contended by the London Senior Counsel, is that the petitioner has been sought to be replaced by the respondent number 4, who is holding the substantive post of Subdivisional Food and Civil Supplies Officer, within bracket, as the FCSO. And in the first also you write the FCSO, okay, in district, okay. It is submitted that the two posts are of different cadres, and the petitioner is holding post in a higher cadre and is also the senior most in the said cadre. Full stop. He has also submitted that the transfer has been sought to be done on the basis of certain recommendations of political persons. Para. Let notice be issued, returnable on 27th of April 2020. Can you serve before that? Is it possible to serve notice on the respondent, private respondent?
27.
On 4th, then 4th of May,
4th of.
or whichever date you say. Sri, Madam, for Learned Government Council for respondent number 1, accepts notice, and Sri Jamu, the Learned Standing Council, Food and Civil Supplies, for respondent numbers 2 and 3. Extra copies. Let notice be served upon the respondent number 4 by speed post with AD. Steps within 2 working days. Para. Sri Party, the Learned Senior Council prays for an interim order. Full stop. He has contended that the submissions advanced in support of the interim order has already been mentioned, has already been recorded above. Full stop. This court has, however, been informed that in the 29 districts of Arunachal Pradesh, there are sanction posts of DFCO. There are only 18 numbers. 18 numbers. Full stop. The impugned order also clearly reflects that the respondent number 4, though was in the substantive post of SDF CSO, was already working as in charge DFCSO Anini. Full stop. This court has also been informed by Sri Jamu that the petitioner is at Pasighat for the last 14 years, and the respondent number 4 has also completed 3 years at Anini. Full stop. The recommendation made by political persons have also been perused carefully, which appears to be about a year ago. Full stop. Under those conditions, this court is not inclined to pass any interim order.
Your Lordship, could it be on 5, my lord, instead of 4, my lord?
We can have it on 5th. 5th is the division bench day.
No, my lord, in that situation, if they will release or such will be handed over, interim is needed. Because matter is
We have
pending.
declined it. We are not inclined to pass interim order.
All right, my lord.
Yes, next.
Item number 7.
Yes.
Yes. My lord, this is for disposal of the reputation. Before coming to the point, my lord, the state government, Eastern Border Pradesh has constituted a high power committee for the bonded labor as per the direction of the apex court. So accordingly, the committee has constituted in the final after final resolution. Relief was sought. Relief was recommended to the government, and the basic claim of the petitioner is the relief was also contained, particularly contained in page number 27, my lord. So on the page number 20,
What is it here? Some representation is required to be considered and disposed of by the high-powered committee. It's not been done.
not been done, my lord.
It's more than a year.
Yes.
You take instructions, Mr. Rappin? Yes. Okay, heard. Pre M. Nibo, learned counsel for the petitioner who is aggrieved by the delay in considering and disposing and disposal of the representation filed on 17/6/2022.
Yes, my lord.
Followed by reminder by the High Power Committee constituted as per directions of the Honorable Supreme Court as well as this court.
This court.
That notice be issued, returnable on, give an early date. Which date? Can you come back on 20? No private respondents. You can come back early. I think today is 6th. We can come back on 27th. 27th. Returnable on 27th. 4/3 S. Tapin Lada Senior Advocate for both extra copies. Pendency shall not be a bar for consideration and disposal of the representation in accordance with law.
Most obliged.
Item number 8.
May it please, Your Lordship. But, this is in continuation to the issues raised in the earlier writ petitions, my lord. My lord, the first issue is, my lord, in the assessment report, it is shown as from 600 meters to 1600 meters, my lord, kilometer. Now, my lord, if we see this page 54, my lord, kindly come to page 54, column, third column, my lord, this measurement is only up to 10 kilometer. So in effect, this has left out 10 to 16 kilometer. And there we had our properties also, my lord.
Now, my lord, will issue notice at this stage.
My lord.
Heard 3T party. You're only one petitioner.
Yeah, one petitioner now.
Learned counsel for the petition.
Being authorized, my lord.
Who is aggrieved by the action of the respondent authorities in trying to revisit the entire aspect of assessment by constituting fresh boards. Full stop. The learned counsel has submitted that the issue was earlier looked into by this court, which in WPC
160
160 of
and 202, my lord.
In WPC 160 of 2020
24
and 260 of
2024
24, which were disposed of by an order dated 3/11/25.
Yes, ma'am.
Full stop. However, without following the direction, the authorities have exceeded in their jurisdiction. Let notice be issued, returnable on first is holidays. On 4th of May. Who will take Mr. Ratan for?
I'll appear for 1, 2, and 3.
And Ratan Lanet AG for 1, 2, and 3. And Madam?
Lordship, I'm appearing on behalf of PHM Kato for Recruitment number 4 and 5.
Okay, your name please, okay?
Four January.
Okay, Miss, where is Miss So-and-so, learned counsel appearing on instruction of 3M Kato Learned Deputy SGI for 4 and 5 extra copies. Okay.
Obliged.
Obliged.
Item number 9.
Your Lordship, I'm appearing on behalf of Yudhika on the instruction.
Yes. What is your submission, madam?
Your Lordship, on the last occasion, we have relied on Rekha Devi and that 1998 notification, but the respondent council pointed clause 5, which regards to it said that it will affect from on that year. So they will.
Yes, we have considered this on the last occasion. Yes, you remember.
Malad, as per the instruction, Malad, I have received the one document, Malad. Malad, ex-gratia scheme, Malad, started in the year 1993, Malad. There was no any such, Malad, earlier. And even in 93, Malad, the case of the petitioner is 1992, Malad.
True, correct.
In 1993, Malad, it is start, Malad, with 1 lakh rupees, Malad.
Okay.
So therefore, Malad, these rules, notification, Malad, other things are not applicable in the case. So therefore, on the last occasion, Malad, the state government has barely made a submission, Malad. They are ready to pay, Malad.
2 lakhs.
2 lakhs,
2
Malad.
lakhs, I think it's better.
Malad.
Okay, we'll close this then.
Yes, Your Lordship.
Madam?
We have no objection.
We dispose this of, huh?
Yeah.
Heard, madam, your name, huh?
Yes.
Are you on record, madam?
No, Your Lordship.
Heard, Mr. and so learned counsel appearing on instruction of Sri U. Dekas, learned counsel for the petitioner. Also heard Sri M. Katu, learned deputy SGI, as well as Sri N. Ratan, learned additional advocate general, Arunachal Pradesh. Full stop. The claim in this writ, please have your seat. The claim in this writ petition is with regard to ex-gratia for the death caused to the husband of the petitioner, who was a constable of the Assam Regiment of the Indian Army. Full stop. The death was admittedly in the year 1992. Full stop. The petitioner has based her claim on certain notifications which were issued much later than the year of death. During the deliberations, this court was also during the deliberation, the learned deputy SGI had placed before this court certain other notifications, including a notification dated 22/9/1998, as per which however clarified that the same would cover cases which are on or after 1/8/1997. Full stop. As the death in this present case was admittedly in the year 1992, this court had accordingly directed the learned deputy SGI to obtain instructions with regard to the position which would govern the cases prior to 1/8/1997. Full stop. Sri Kato, the learned deputy SGI, has submitted that as per instructions received, the scheme of payment of ex-gratia started in the year 1993, wherein the amount stipulated was rupees 1 lakh. Full stop. He has accordingly submitted that that no ex-gratia would be payable to the petitioner regarding the debt which was in the year 1992. And at best, if any such ex-gratia is payable, the same would be only to the extent of rupees 1 lakh. Para. At this stage, comma, Sri N. Ratan, the learned AAG, has submitted that as per instructions received, the state government itself had examined the claim of the petitioner and has come to a conclusion that ex-gratia of rupees 2 lakh
Yes,
would be payable.
although his case is not.
Would be payable as an exceptional case. Full stop. However, the amount was not acceptable by the petitioner at that time. Full stop. Para. At this stage, comma, Ms. So-and-so, learned counsel for the petitioner has submitted that since the claim was based on the central government notification, and admittedly, at the time of death, there was no such notification, and the earliest notification and the proximate notification would be of the year 1993, as per which the ex-gratia is rupees 1 lakh, comma. Her client would be satisfied if the amount stipulated by the state government is paid to her. Para. In view of the aforesaid submission, comma, this petition is closed by directing the state government to release the ex-gratia amount of rupees 2 lakh to the petitioner expeditiously and preferably within a period of 2 months. Is it okay? Or 45 days? You tell us.
Yes, 2 months.
2 months from the date of receipt of a certified copy of this order. Para. It is, however, clarified that the present payment would not be deemed as a precedent for any other case. Petition stands disposed of.
Item number 10.
May I please, my lord? My lord, here my lord, petitioners are aggrieved by my lord awarding of rupees 11 per square meter for an land acquired for construction of the.
IA4? Item number?
Item number 10, my
10,
lord.
10, 10, okay. Okay, now what
My
is
lord,
the
here.
stage? Pleadings have been exchanged.
Yes, my lord.
In fact, time in malad. Again, malad, we reminded to the malad PRO malad for participating of the malad affidavit malad. They are malad not under participating. In fact, malad later.
You have filed additional affidavit today.
No, the state has filed, my lord.
Additional affidavit, malad, earlier our stand was that.
Have you filed it today?
Yesterday.
Yesterday, 6/4. Okay.
Yes.
Is it on record? Okay, placed on record. Yes, yes.
In fact, our earlier stand was that since the Mihin Laling case is pending before the Honorable
Supreme
Apex Court,
Yes.
so there is no, we have rightly prepared the estimate as per the jailer, under the jailer. Now that has been disposed of. Now here, our in the additional affidavit, now since their case will be covered, that they are entitled for solicitation and interest, my lord. Our contention is that the notification of rate applicable at the time when the acquisition notification was issued, that is of 2011. That will hold the field, not the subsequent. The rates, because this notification for this particular stretch of land, it was issued in year 2021.
And the acquisition was which year?
Acquisition was of 2021. Now,
what is the claim of Mr. Saikia? He's seeking a claim of a subsequent, as per a subsequent notification.
No, my
lord.
No, my claim is, my lord, the rate has to be, my lord, in terms of the, my lord, 2013 Act, my lord. Because, my lord, the 2013 Act was adopted in the year 2014 itself by the government of Arunachal Pradesh, my lord.
Acquisition was of which year?
Of 2021, my lord. And the award was passed on 2023, my lord. 21, my lord.
So I think his claim would be justified.
Yes, my lord.
My lord,
Particular
our
objection.
difficulty is that as per this, that at the time in 2021, the rates which was holding the field is of the notification of 2011.
subsequently in 2022, notification has
No,
been.
see, whatever rates were there after coming of the 2013 Act
Yes.
and the judicial pronouncement has always said that you have to give the higher rates. There is no doubts or any dispute on this aspect. You cannot fall back on a rate notification of 2011 when the acquisition itself is of the 2022, and by the time 13 Act has already come into existence.
Yes, my
That
lord.
will not be a correct stand. You can take instructions. You can take instructions.
My lord, that may be recorded, my lord. My lord, because there is some confusion in the department.
No, there are many. Are you equipped with the case laws?
Even
acquisition proceedings, even acquisition proceedings which were initiated under the 1894 Act, if it was not completed, then the rights as
Yes.
per 13 has to be given.
Yes.
13 has to be given.
And there is a provision. Where is the
Section
Section 24, my lord.
24.
Section 24, my lord.
Please,
And,
Acquisition Act, new Act. Oh, yes, we have.
Section 24. Or determined, but not paid.
Twenty-four proviso is very clear. And what about the transitional aspect? In transition, what would happen? There is another.
Okay. 24.
There's something on the transition thing.
Section 24 is that.
74.
24.
24 we have seen.
Yes, that is the transition, my lord.
my lord, in Mihin Lalin case also, my lord, it was observed, my lord. My lord, I have.
Do you have a copy?
Yes, my lord, I have filed, my lord, additional affidavit, my lord.
Yes.
In that, my lord, I have annexed the, my lord, Mihin Lalin case, my lord.
Okay. We can dispose this of them?
Yes, my prayer will be that, my lord, let the, my lord, the award, the estimate be set aside and let Deputy Commissioner take a fresh call, my lord, and pass a fresh award, my lord. We will, my lord, produce evidences of, my lord, the market value, my lord, before the, my lord, Deputy Commissioner and.
But market value cannot be of subsequent today's date. Market value has to be a date, has to be of a date at the time of acquisition.
Yes, my lord. Yes, yes, my lord. That's why, my lord, before in the same stretch of road, my lord, there are, my lord, instances, my lord, where, my lord, rate was given, my lord, at the rupees, my lord, 250 and 264, my lord, in the same stretch of road for the same highway, my lord. That I will, my lord, produce before the, my lord, Deputy Commissioner, my lord. We have also annexed those awards here, my lord, in the writ petition also, my lord.
My lord, under section 26, we have to ascertain the market value, my lord.
Correct.
The problem here, we don't have documents to ascertain the market value in Arunachal Pradesh because
So that you can do with the assistance of the land affected persons.
Yes.
They have to produce the relevant documents. You can look into the documents, whether those documents are valid, where the veracity of the documents can be looked into. Then you can take a call. It's not that all the documents you'll have to accept. It will depend on your discretion, your wise discretion. Which document is genuine, which is bona fide.
Therefore, our stand was that since under section 26, the market value could not be determined. So we had fixed a price rate for leads.
But that is of 2011.
Yes, madam.
How can you do it?
That is 2022 we have, but
11 to 13, this could have been a valid submission. But after coming of the 13 Act, you cannot fall back on a notification of 11 if it is prejudicial to the land affected person. If the market value was more than what 13 says, then 11 would prevail.
my lord, may record my submission, my lord. That
But because, my lord, in the vicinity of the, my lord, area, my lord, it's the same stretch of road, there were, my lord, instances, my lord, where higher rates were given, my lord. We can, my lord, produce those evidences before the deputy.
But is there a scope for
that those acquisitions were after 2022. So
no.
That
My lord, one is, my lord, of 2019.
now?
Also
What
there.
is the scope now? What direction can we give? What is
reassess to reassess, my lord.
reassess
Yes, ma'am.
for making the award?
Yes, ma'am.
Then he can be given an opportunity to place all documents. He will consider. Okay.
Yes, ma'am. My lord, that submission that our stand that state has put forth this argument that 2000.
So what is the notification 2011?
To page 54, I have also annexed, my lord, the lane rate, my lord.
No. What is the notification date? 2011.
2011, 26 November. 26/11/2011, page 54.
All be true. Your land has been acquired
By notification, my lord, dated 27/4/2020, my lord. Okay. And Government of Arunachal Pradesh has adopted the, my lord, 2013 Act by a notification dated 23/2014, my lord. Page 57, my lord.
and the issue was not looked into as because this state was pending. What was pending?
The Mihin Laling case, my lord.
You have given an additional affidavit. Page?
Yes.
In my additional affidavit,
Page?
my lord, page, my lord, 244, my lord. The judgment entered by the Supreme Court, my lord. Relevant portion is there, my lord. Paragraph 24 onward, my lord. Thank you. And my lord, paragraph 25, 26, and 26, my lord, regarding solicum and interest, my lord.
Okay. Please write.
I'm for the respondent number 3 and 4, madam.
29 numbers of petitioners have joined together in this petition instituted under Article 226 of the Constitution of India, seeking the following relief. Page 47, please close the relief. Para. As per the facts projected, the petitioners are permanent residents of the locality and were affected by the widening and improvement of the national highway. DL means? What is DL?
My lord, NHDL, my lord. It's the name of the road, my lord.
Improvement of the existing road to NHDL specification in respect of Hawiliang dash Changwinti between 45.05 km to 50.820 km and Changwinti dash Walong dash Namti from 00.00 km to 54.450 km in the Anjao district. Full stop. You check from the synopsis, these details. The rate, however, which was proposed of rupees 11 per square meter was, however, opposed by the petitioners as it was absolutely meager. Full stop. The contention of the petitioner is that the applicable rates which would be relevant, which should appear from the relevant materials were not taken into consideration, whereby the petitioners would be deprived from their legal entitlement. It is also contended by the petitioners that the provisions of the right to fair compensation Act of 2013 bracket wherein after Act of 2013 have not been followed, and the petitioner and the respondents have relied upon a notification of 2011 which would not have any relevancy. Para. I have heard three. R. Sekia, learned counsel for the petitioners. Para. I have also heard three. And Ratan, learned AAG, Arunachal Pradesh, as well as Sri M. Kato, learned deputy SGI. Para. Sri Sekia, the learned counsel, has submitted that after coming of the 2013 Act, it is incumbent upon the respondent authorities to pay the compensation strictly in terms of the same as the Act in specific terms has laid down, that even for existing proceeding under the earlier Act or under the earlier Land Acquisition Act of 1894 has to be converted to a proceeding under the 2013 Act. Full stop. He has also submitted that the concerned Deputy Commissioner has not taken the relevant factors into consideration. Full stop. He has submitted that for acquisitions done in the adjoining areas, the rates are much higher in the range of
250 and 264
250-260 per square meters. Full stop. Para. Sri Ratan, the learned AAG, has, however, fairly submitted that the that a re-verification was not possible in view of the pendency of the case of so and so before the Honorable Supreme Court. Full stop. He has, however, informed that the said case has been disposed of by the Honorable Supreme Court on 16/9/2025. Full stop. At this stage, Sri Saikya, the learned counsel for the petitioners, has informed that an additional affidavit has been filed wherein the judgment dated 16/9/2025 passed by the Honorable Supreme Court has also been enclosed. Para. Sri Ratan has also submitted that under section 26 of the Act of 2013, the collector is required to determine the market value. Full stop. Since no materials were available at that time, the state government had relied upon a notification dated 26/11/2011. Full stop. He has, however, not disputed that the land was acquired in the year 2020. Full stop. Para. Sri Kato, the learned Deputy SGI, has endorsed the submission of the learned State Council and has submitted that the compensation paid should not be a windfall and should be a fair compensation as per the entitlement in accordance with the Act of 2013. Para. The tribal submissions have been duly considered and the materials placed before this court have been carefully examined. Para. The Honorable Supreme Court, in the case of ... White judgment dated 16/9/2025, has clearly laid down that the provisions of the 2013 Act should be applied for assessing a fair compensation. So in the said case, the aspect of payment of solicium and interest has also been highlighted. Full stop. Para. Under section 24 of the Act, more specifically, the proviso thereto would show that compensation, even if assessed as per the earlier Act and not paid, would, however, be converted to compensation as per the Act of 2013. Full stop. The intention of the legislation of 2013 is to ensure that a fair and proper compensation is made to the land affected persons and nobody is deprived of their due. Full stop. There are various other aspects in the Act of 2013, including solicium and interest, which would also have to be a part of the award. Full stop. Para?
As required in the Schedule 1 of the Act, my lord.
Award including Schedule 1 of the Act. Full stop. Para? The determination of the rate of ₹11 per square kilometer appears, prima facie appears to be on absolutely on the lower side and cannot be treated as fair compensation. More so when the materials on record both suggest that for adjoining areas, higher rates have been determined. Full stop. Be that as it may, comma, this court is of the view, is of the opinion that the entire assessment has to be done, has to be done afresh by taking into consideration all the relevant factors, including the rates applied for acquisition of land in the adjoining areas, provided such acquisition have been done in the contemporaneous period. Full stop. It is also needless to state that all other provisions of the 2013 Act, which have been incorporated for the benefits of the land affected persons, are to be taken into consideration while assessing and determining the rate to be paid to the land affected persons. Full stop. Para. The writ petition accordingly stands allowed by remanding the matter to the concerned Deputy Commissioner Anjao to make the reassessment in the manner indicated above. Such process be undertaken and completed expeditiously and preferably within a period of 3 months. 3 months from the date of receipt of a certified copy of this order. Full stop. It is needless to add that the petitioners or any other aggrieved party would still have the liberty to approach the appropriate forum if they are aggrieved by the award in accordance with law.
My submission may kindly be recorded that in view of the Mihin Laling's case, the state is ready to pay the solution and interest, but by maintaining the rate of 2011.
2011?
That submission only.
But we'll reject it.
Yes, madam.
You write in between, huh? Sri Ratan had submitted that in terms of the judgment of the Honorable Supreme Court dated 16/9/2025, the state is willing to pay the solicium
and interest.
That you are only to pay.
Yes, that is there but maintaining the rate of 2011.
By as per the rate of the rate mentioned in the notification dated 26/11/2011. Later you know, right? Huh? So far as the payment of interest and solicium is concerned, this court is unable to accept the submission of the Learned State Council so far as it relates to the notification of 26/11/2011, inasmuch as after the enactment of 2013, it is the Act, it is the provisions of the Act which will govern the field.
One thing, my lord, the Secretary Land Manager is not the paying authority, my lord. The compensation will be paid by the requiring agency, my lord, the grave, my lord.
Yes, that is already, we have not said will.
Okay.
Item number 11 and 12.
Yes, IA for?
The IA is for the stay of the examination process, for the process of the recruitment. And
I'm sorry, my lord, despite our reminders, we have not yet received our
What is the stage of the recruitment?
Lordship,
What is the stage of the
now
recruitment?
interview is going on, your lordship. Written already done, result declared. Now interview is going on, your lordship.
But you have to then incorporate a clause that or any appointments made would be subject to outcome of this writ petition. If he makes out a case, because you are on the aspect of the quota for PWD.
Yes.
If a PWD case is made out, the persons who are falling in this category cannot be left out, cannot be deprived.
Whereas unfortunately, they could not qualify in written examination.
But is there any benchmark?
Yes, there are so many.
No, for PWD, the benchmark would be less. Well, is there any difference in the benchmark of PWD and normal candidate? Apart from the quota is different. But is there a benchmark? Suppose a unreserved candidate or a general candidate secure, he has to secure a minimum 50%. Is the PWD also required to clear 50% or is the benchmark?
My lord, to my knowledge, my lord, all the benchmarks are equal, my lord.
That benchmark you have to cross over. Then you have a particular category. That in that category, even if you score less.
Minimum benchmark that has to be.
Okay, then, you have not passed in the written.
That is not the issue, Your Lordship.
Have you filed affidavit?
Yes, I will.
You filed. And Mr. Adnan, when can you get the instructions?
My lord, despite our repeated.
Wednesday next. Wednesday next will be holiday.
See, as per the last order, there was an order that if they fail to file affidavit by this date, then the case will proceed in absence of the affidavits.
Without the affidavit of the respondent, you are correct.
Yes, my lord.
But if you have not passed the written,
no,
what kind of interim can you?
Now, Your Lordship, my case here is that the illegal seat reservation, and the fact that I have not passed the interview, that is not the issue here, Your Lordship. No, Your Lordship, any case has to be decided and educated in context of the situation it was when it was at the time of filing. That is one issue.
No,
And-
we'll definitely examine that.
Yes, yes.
But unless you pass the written examination, where is the scope of your consideration?
Now, Your Lordship, that
We
again,
cannot have an academic exercise.
now, Your Lordship, the second issue is that apart from the petitioner number 1 and 2, there are 2 more petitioners. In that the 2 petitioners, some persons have qualified in the petitioners.
I have 2 of the petitioners qualified.
No, I mean, Your Lordship, the petition number 3 and 4.
How many petitioners are there?
No, 3 and.
No, Your Lordship, kindly see.
1 and 2.
2 petitioners are there.
Yes.
Yes.
No, Your Lordship.
3 and 4 are.
3 and 4.
4 are.
Yes.
Associations.
They are the association. So in this association, we have some other members who have qualified.
Now, where have you stated? Have you stated?
No, it was not stated in the main petition, Your Lordship.
You have to state it.
But because Your
Now,
Lordship,
since it has come only 2.
no, Your Lordship, this petition was filed before the exam began, Your Lordship.
Now, in the examination, it's a clear stand that the 2 petitioners who are citizens,
Yes.
1 and 2, they have not qualified. If you want to contend that there are members of 3 and 4 who have qualified, you state on affidavit
Then in that case, Your Lordship, I'll state an affidavit on the next day.
immediately, okay?
So the matter will be listed after the puja vacation, Your Lordship.
Not puja.
The
Puja vacation will be on October.
No, I mean this vacation. Yeah.
Okay.
Bihu break.
Bihu break, yes.
Okay. What is your name?
K. Taja.
Heart Sri K. Taza, learned counsel for the applicants. Also heard Sri N. Ratan, learned AAG. 3. Who is appearing?
Jitara.
I am for respondent number 7.
For respondent, you are for sending counsel to which department?
RWDS.
RWD.
I'm for the respondent number 9.
And then N. Anju, learned counsel for the APPSC.
Lordship, 2 and 3.
2 and 4. You please write their names, okay? You know their names, sir? 9. 4 and 5 you write before, then 9, huh? Please get the names, okay? Para. During the deliberations, the learned counsel for the respondents have contended that the petitioner numbers 1 and 2, who are citizens, have not been qualified in the written examination. And therefore, the scope of their of providing any relief would not arise. At this stage, the learned counsel for the petitioners has informed that the petitioner numbers 3 and 4 are association, and few of the members have indeed qualified. Full stop. Let the said respect be put on record by way of an affidavit.
And Your Lordship, one more.
For which 1 week's time is granted. Okay, we fix a date.
After vacation, Your Lordship.
Tell us, list on 27, is it okay?
27, yes.
Monday?
Your Lordship, then 23.
23, okay, 23 is Thursday. Thursday there will be division bench. You take 24 or 27.
Then Your Worship, first week of May.
Okay, then 4th of May?
Yes, Your Worship.
It okay, 4th of May.
Oblong. And Your Worship, one more submission that I'd like to give is that that I was that the 1 and 2 we couldn't qualify because we have been deprived. No seats are reserved for us.
See, you put that on affidavit, this part also we'll see. Okay, any other?
Item number 13.
But it may not be possible to. That's why you have- Yes, what is this?
My lord, this is the fact of the case, my lord. Without any land acquisitions, without any survey, without any fair compensations.
You have filed the opposition.
Yeah, my lord, I have already
You have
obtained.
filed reply.
I have already obtained, my lord, they're not required for the reply.
Reply is not required.
Not required, my lord.
Then we can have this for admission hearing.
No, sir.
When do you say?
Uh,
On 23rd, 22nd?
23rd.
23rd Thursday again,
Okay.
or 24th?
24th.
24th? You will not file any rejoinder affidavit?
No, my lord, the matter may be, hey, if time there, let me take up today's.
Today it will not be possible.
Okay, my lord.
Today second half we have difficulty. There's some program, important program, and 5 minutes will not be possible. Otherwise you'd have taken up.
Yes, yes, sir.
Your luck, or maybe you'll have a better opportunity on 24th.
Okay,
Okay.
okay.
Heard your name?
P. Bui.
P. Bui, learned counsel for the petitioner. Also heard Sri N. Ratan, learned senior government advocate, Arunachal Pradesh, who submits that affidavit in opposition has been filed. Para. Sri Bui, the learned counsel for the petitioner, has submitted that rejoinder affidavit may not be necessary. Para. In view of the above, list this matter for admission hearing on 27th.
27. 24?
No.
27 April, Monday.
Okay.
Okay for you?
Okay.
Unlisted item,
Which one?
that morning one. This
This
unlisted, yeah, it has come. Unlisted item number 14 to 19.
Lordship, for that first two items, my lord, I will be seeking more in that one, so I will my lord, let it be listed in usual course, my lord.
Oh, these are not connected.
It's connected, but my lord, I have to, there we will be seeking more than what we.
14 and 15, huh?
Yes, sir.
Though this matters, a separate matter, though this matter has been listed on the strength of a mentioned memo. We listed by making a mention this morning, along with some other matters, Sri Tafo, the learned counsel, has submitted that he would like to argue this separately.
Yes.
As the same may not be covered by the judgment dated 6/4/2025,
Yes.
passed in a bunch of writ petition, including WPC
380.
380. Accordingly, list this matter after a week.
Yes.
This will be same order in 14 and 15, huh?
Yes.
Then 16, 17, right?
16, 17, my lord, the only difference was that the assessment was same, everything was same. Only ground they have taken is that now it's not, it doesn't come under ROD after demolishing all the structures. Then there was an interim order that also there was some structure left. This honorable court passed in.
Not similar.
That's not same.
Why have you mentioned this?
My lord, what we are seeking is
But we'll have to apply our mind. We thought it will be covered.
my lord, what we are seeking is the assessment which was already made in 2016, my lord.
But we do not know whether the land has been given back to you.
No.
Huh?
Now road has already become, it's true now, my lord.
What about the land?
Just by on that land, road is true now. Even after
It's not been covered by the road.
no same road, my lord. There's
No,
package.
initially you had said that the alignment has not covered your land, though initially it was proposed.
No, it was. That's why, my lord, everything assessment was made prepared in 2016 itself.
Not be proper without any.
Yes,
application.
then lordship.
And which any item covered, not covered? None of the items.
Not covered.
Mr. Tafo, you should have taken a call.
No, my lord, because the gist was same, my lord.
No, no, it will not be proper. Then you write the same order
Yes.
in all the cases.
Yes.
After a week, you try after a week.
Yes, madam.
You should not do some things in hurry. Otherwise, it will be a problematic one.
That's why, madam, 14, 15, I have mentioned that.
Others also. Others, no matters are covered, I think. Let it come after a week. If it is covered, then also after a week you can place the judge.
Yes, yes.
Okay.
I'll much obliged.
Okay. I'll request all of you to come to the auditorium.